This is Paul Turner, the Immigration Browser at Imperium Chambers. Please subscribe to my channel and hit the notification button for all the immigration news as it happens. Well, there's some excellent news today to report. The High Court confirmed that Zambrano carers will not use their EU right to reside just because they have permission to remain granted under a route other than Appendix EU. This is fantastic news for people who think they might be Zambrano carers. They can now apply under the euss, and I would encourage anybody that thinks that they might qualify to get in touch with me as soon as possible. There are still many things to consider when deciding whether to apply under the EUS or the immigration rules. As I've mentioned, if you think you might be a Zambrano carer, do get in touch urgently as the 30th of June 2021 deadline is fast approaching. Now, the law which gives rise to this important change, really. The recent case of R on the application of Akinsea, I probably pronounced that wrong, versus the Secretary of State for the Home Department, 2021, EWHC 1535, admin, for those that are interested, has provided welcome clarity for Zambrano carers, who so far have been refused under Appendix EU by the Home Office, where they have already had some sort of permission to remain. By way of background, Zambrano carers are named after the landmark case of Zambrano, which dates from 2011, and refer to the primary carers of British citizens who live in the UK, where the carer's removal would compel the British citizen to leave the European. That's what they were, and they were granted leave as a Zambrano carer, and it was called a derivative right, and it supposedly didn't lead to any form of settlement. This has now changed. This applies, for example, to single parents from non-EU countries who have British children, or carers of elderly British people. So it covers quite a lot of people, and there are quite a lot of people that have got visas under Zambrano. Zambrano carers have faced a lot of uncertainty with the introduction of the euss. It appeared at first that they wouldn't be covered by the scheme because their status depended on EU law, and of course they weren't EU citizens themselves. Then the Home Office changed their mind and said that Zambrano carers were eligible under the scheme, but would only get indefinite leave to remain once they'd been in the United Kingdom for 5 years as Zambrano carers. So you might think it was all settled and Zambrano carers would qualify. But there's another twist in the tale. The Home Office then said that they were only eligible under the euss if they didn't already have leave to remain in the United Kingdom, unless this was granted under Appendix EU, which doesn't really make any sense, it's contradictory. Apparently their logic was that if the Zambrano carers had already got leave to remain, then neither the carer nor the British citizen would be compelled to leave the United Kingdom. What this meant was, in practice, that many Zambrano carers were unable to use the euss, and these were mostly single parents, again targeting the most vulnerable in my view. They had to choose between applying for a pre-settled Zambrano residence card or as leave to remain as the parents under the normal immigration rules. The immigration rules were far more attractive because you could receive benefits and there were routes to settlement. Then the Home Office started rejecting almost all Zambrano cases under the euss, which of course is not expensive to apply for. However, Mr Justice Mostyn, in the recent case, has confirmed that the Home Office were wrong in law to exclude Zambrano carers from the euss. He essentially stated that Appendix EU of the immigration rules, which replaced the EEA regulations, etc., had been unlawfully drafted. No real surprise there. As I've mentioned, the EU settlement scheme closes on the 30th of June 2021, so it is incredibly important to contact us as soon as possible if you are a non-EU national who cares for a British person. We can help you to apply for the appropriate form of leave and get everything done before the 30th of June deadline if you get in touch. So I hope this video has been of use. Thank you very much for watching. Please stay safe. This is Paul Turner, the Immigration Barrister at Imperium Chambers.